Hello everyone, welcome to my channel. So in this video, we are going to discuss about the contract law prior to the Indian Contract Act. So in the ancient times, we do not have specific law for the governing the contracts. So there we used to have Hindu laws and Vedas, which will be adopted for governing the or doing the contracts. So for example, there is something called barter system. So in the past barter system, people used to exchange their respective services or goods in return to the other ones. There is no concept of money there, and Mughal rule in India, contracts were governed by Mohammedan law of contract. So in that, there are some Arabic words which are governed. So they've used something called ijab for proposal of contracts, and Kabul is used for acceptance of contracts. And there is something called act. This is used for conjunction. That means the continuation of the contracts. So there was no specific rules and regulations in order to form a contract according to the Islamic law. But however, they need acceptance for a specific contract, which means the same thing in the same sense. That means the offerer should offer the same thing, and the acceptor should also understand the same thing in the same sense. That is a major requirement during the in the Islamic law. Next, we are going to discuss about the Hindu law. Hindu law is basically different from the English law, and the Hindu law is basically coming from the Vedas and also the customs which are specified by the Smritikaras, who developed the Vedas into the respective laws and rules and regulations. So, according to the Hindu law, a person who is intoxicated, a minor, an old person, or handicapped person are not allowed to enter into a contract. And according to the Narada Smriti, a person or children who are up to age of 8 years are called as infant. 8 to 16 years are called in the stage of boyhood. At the age of 16, they are eligible to participate or enter into a contract. So that is according to the Narada Smriti. During the British period, law of residency is applied for the presidency towns Madras, Bangalore, and Calcutta. For other places, the matters were solved based on justice, equity, and conscience. So this was the process followed until the Indian Contract Act came into force. Thank you. Let us now move on to the basic introduction of the Indian Contract Act 1872. So the Indian Contract Act was formed on April 25th, 1872, but of course it came into force on September 1st, 1872. So there are different sections in the Indian Contract Act. So the section 1 to 75 are related to the general principles for all types of contracts. So there are different principles which are specified in section 1 to 75. These are applicable to all the types of contracts irrespective of their nature. And there are few other contracts which are specified in section 124 to 238, like bailment, pledge, quasi contracts, etc. So these are all special contracts. So we'll be discussing in detail about that. But the special provisions are described in section 124 to 238 in Indian Contract Act. So the major types are bailment, pledge, and quasi contracts. Yeah. Indian Contract Act generally specifies the basic rules and regulations that are required to create or form a contract. So we'll be determining whether a contract is legally enforceable or not. So what is meant by legally enforceable? That means if there is any problem in the contract with either of the parties, it should be enforceable with the law. That means they should be able to file a suit with the court of the law. So that means the legally enforceable. So we'll be determining the several factors whether a contract is legally enforceable or the circumstances where the contract is legally enforceable. So generally, the Indian Contract Act 1872 specifies the minimum or basic requirements or ingredients that are required for framing a contract. Now discuss about the answer to the first scenario in the related video. So you can check out that video in the link given to the video. So the first question is related to the sale of immobile property. So whether a transaction which is governed by the Sale of Immobile Property Act needs to be obeyed with the Indian Contract Act provisions or not. So this gives us the answer. So the section 1 to 75 specifies the provisions that are applicable to all the contracts irrespective of their nature. So even if a contract needs to be entered by the persons for selling or purchasing of the immobile property, it needs to be taken care of by the provisions specified in the Indian Contract Act 1872.